Greetings to everyone present. My name is Ankit Malhotra. I'm a Felix scholar and advocate. I would like to begin by thanking the organizers for allowing me to present my thoughts and perspective. It is a pity and it is completely my loss to not be in Mozambique with everyone and to share my thoughts nonetheless is an honor and a privilege. Now, without wasting further time, I'd like to discuss the key elements of this paper, which I have spent sufficient time on and have even been able to match it with practice as well. However, in order to give an understanding, it is also important to give a bit of perspective. And in order to do so, it is important to understand that the majority of the African countries could benefit by becoming state parties to the 1970 UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of cultural objects. However, the 1972 convention has not seen much muster with African states. By all accounts, African states appear to be the most vulnerable of any groups of illicit trade of cultural property. There are, of course, different distinctions and discussions which have taken place in order to explain this. However, this sensitive study is also aimed at the African authorities that will much benefit if join the convention and become a part of also the UNIDROIT convention, which this paper will discuss at length in depth. However, these legal aid costs and presentations of claims in foreign courts to recover objects is something that pinches the African countries and their limited purses. As one has often said, while the arms are long, the arms are short, while the pockets are deep, finds significant resonance in this case. However, what one must remember is that the focus of attention must be on the colonial times. Of course, there are UN General Assembly resolutions, but in this regard, what is important is Resolution 3187 of 1973, the restitution of works of art to countries that are victims of expropriation. The resolution, in its preamble, declared and deplored the wholesale removal, virtually without payment, of objets des arts from the home country to another, frequently as a result of colonial or foreign occupations. In this regard, the just reparations of damages is something which must be noted. In 1978, a plea for return of irrepressible cultural heritage to those who created it was also enshrined. There was also further lamentation by the Director General of UNESCO, who said the vicissitudes of history had robbed many peoples of priceless portions of irreplaceable masterpieces of their inheritance. Such declarations have found deep resonance. However, resonance in court must be substantiated by claims. Claims have often in courts left to limited avenues and exploration, therefore curtailed the possibility of reparations given lack of funding, support, and also judicial processes which are time bound and horribly slow. To expand on this further, we must consider that litigation in foreign courts is bewildered by two intricate problems. First, the prosecution is often difficult with regards to stolen objects because of the evidentiary problems. And second, in breach of export controls and the widespread rejection of reluctance by foreign courts of legislative extraterritoriality is well exemplified in the case of Attorney General of New Zealand versus Ortiz. In a few cases, African countries can afford these expenses involved in foreign litigation are a dime a dozen. UNESCO Convention also offers an interesting avenue. As we shall see, the African states still have no ground to further their objectives of systematic inventories of their cultural heritage properties. As was noted in R versus Heller, in which the government of Canada prosecuted a New York dealer who had imported into Canada knocked terracotta sculptures illegally exported from Nigeria. Both Nigeria and Canada were parties to the convention. However, the prosecution failed on technical grounds that Canadian statute implementing the convention only applies to objects illegally exported after the convention came into force. Expert witnesses had been flown in from Nigeria, but despite the best efforts and the spirits of the government, it was stifled as Nigeria was unable to afford costs in cultural property cases such as this. What has also been accepted is that African states do not have resources to prosecute claims in African claims in foreign courts, which have ignored or nullified this option. Another option can perhaps be to look at the UNESCO Intergovernmental Committee. In this regard, the purpose of the recommendations of the committee are to protect national cultures of states by countering the illicit operations which threaten the very existence. The UNESCO General Assembly, UNESCO, and the UNGA Resolution 3187 of 1973 led to the establishment of the Intergovernmental Committee for promotion and the return of cultural property to its countries of origin and through illicit appropriation. However, the committee's sessions and those thereafter have not seen much discussion. Surprisingly, African countries whose agitation at the General Assembly led to the establishment of the governmental committee have made little use of the committee's good offices in recovery of their expropriated cultural objects, which is rather surprising given the importance that must be attained to this. African countries can perhaps point to Greece's request for the return of the Parthian marbles, which goes back to 1984, which remains unrequited. But Greece offers an interesting example for African countries and their object lessons in determination and persistence, which has never failed to raise the return of marbles at all subsequent meetings of the committee, in spite of the regular negative British response. Indeed, the fourth committee of the session convened at Athens and Delphi, and the seventh in Athens in 1985 and 91, respectively, at the invitation of the Greek government, leads up for the African states to focus on the inaction and the lack of stamina for the necessary follow up of these suggestions. A case at point perhaps can also be Affaire du Neige in Pali as a communique issued by the Senegalese ambassador to Italy in its description. What this perhaps needs to be done or noted is that the concerns of the body of African nations has taken up a desecrated grave in Bechuana land, which is now Botswana, in 1830, stuffed and put in an exhibition in Musée d'Art de Babylone in Spain. Representation about this grave was insensitive and was made horribly expansive, but the entire African continent was made several authorities, including the government of Spain and the president of Senegal, as chairman of the Organization of African Unity, which in due course discussed the matter at its ministerial conference in Tripoli in Libya. In 1897, the exhibition of stuffed Negro was deplored as an unacceptable violation of African dignity. The Secretary General of the United Nations at that moment of time was Kofi Annan, and in that he noted that the UNESCO General and the exhibition of the stuffed Negro was eventually withdrawn from display, but at that time, postcards and small sculpted copies of the exhibition had already gone on sale. The objective of the OAU of the stuffed Negro for its reburial in a final resting place was also to be discussed. The Senegalese ambassador was told how the matter could be referred to the UNESCO's Intergovernmental Committee and the additional steps that needed to be taken. The stuffed Negro remains at the museum, and the postcard sculpted copies presumably now traveled around the world. One another option which can be explored are the bilateral agreements and these outstanding efforts of restitution that can be done in this regard. One may only think as far as to the Belgian example in the Democratic Republic of Congo, or the Netherlands to the Indonesia, or the Australians to the Papua New Guinea and New Zealand. These examples or of bilateral relationships which have mustered further and further courage. In this regard, UNESCO and the ICOMOS can also play a significant role. First, the steps is to notify of the international community of the steps of thefts to Interpol. To cite a famous example in this regard would be the 1987 case of UNESCO and the report to the theft of 9 objects from Jos National Museum in Nigeria. One of these objects was a 15th century Benin bronze statue, which was subsequently identified at an auction and later returned from Switzerland. 1983, Congress passed the Convention on Cultural Property Implementation Act, giving effect to the 1970 Convention, which is the beating heart of these disputes. So far, the United States has entered into a treaty with Mexico and has made several executive treatments with Bolivia, Canada, Ecuador, El Salvador, Guatemala, Peru, and lately Cambodia and Cyprus. The only African country to have benefited from this is Mali. The exceptional measure was taken in the wake of the rampant pillage of archaeological sites in the Niger Valley. However, a request seeking the protection of import controls is submitted to the Director of the United States Information Agency, which carries out the President's decision-making function and determines whether a request of merits should be imposition on the import restrictions of the United States of America. The important thing there for the African states is to take initiative, and that often, far too often, is lacking in objective and in purpose. Of course, there are many objects that can be benefited from this restriction, and these need to be included in some sort of a red list which includes objects such as those which perhaps require further attention. The knocked terracotta statuettes from the Bachu plateau in Castilla on Soto in the Nigeria region, terracotta and bronze heads from Ife in Nigeria, stone statues from Is in Nigeria, terracotta statuettes, bronze and pottery from the Niger Valley in Mali, or the terracotta statuettes, bronze pottery, and stone statues from the Burwa system, the stone statues from the north of Burkina Faso and neighboring states, just to name a few. Apart from Mali, 6 other countries such as Burkina Faso, Cameroon, Chad, Ghana, Nigeria feature in the red list, with Nigeria listed in 4 out of 8 categories as identified. Given the pivotal position of the United States as an art importing nation, the lack of initiative on the part of the African countries vis-a-vis the United States of America is a scheme which is designed for failure of African museum professionals deciding to take no measures whatsoever. It is therefore surprising to note that the Amsterdam Conference of some Western experts demanded that Africa must put its house in order is an important evidence which is adduced so far as to show that African states have not diligently pursued the options available to them for protection of their cultural heritage. All in all, a bleak image offers a limited understanding and perspective in this regard. However, arbitration as a process, as a means to an end, presents itself as an interesting case study. Of course, one may look only as far as to Article 8.2 of the UNITROA Convention, which offers an avenue of arbitration for the recovery of stolen or illegally exported cultural objects. It says, and I quote, the parties may agree to submit the dispute to any court or other competent authority or to arbitrate. This, of course, is the imprint of the famous and distinguished Professor Pierre Lalif, a distinguished international arbitrator who was not only a member of the UNIDROIT study group, but indeed chairman of 4 meetings of the government and experts on the draft convention, on the chairman and the chairman of the committee of the whole at the diplomatic conference. The seminal role played by the group, of course, focuses on arbitration for the settlement of cultural property disputes that first came up. Of course, the Intergovernmental Committee held in Istanbul in 1983 was also an important aspect. It was there decided that the second session was once request had been made to the committee and transmitted to the holding country, the latter would be given a year to claim or react. If at the end of 1 year period, the committee felt that the position of holding a country was unjustified, it could extend its court offices or perhaps even an arbitrator in order to find an acceptable solution. Of course, in the discussions, it was also held for the country, the host country, that the idea of arbitration could, on the part of the committee, reduce that to only mediation. To arbitrate, would one suppose to support the position of a particular country? It was discussed. Further held that it was not for the committee to pass judgment in such a manner, but mainly only offer an analysis to the situation for the failure of an attempt to obtain a return or restitution through bilateral channels. Pierre Lalif, in this regard, was quick to respond that the use of arbitration was in a general way, and that the committee had only bring this up if the good officers, the good eager people could find a workable solution. He ended by saying his path of mediation and moral pressure should work in some distinction. Of course, Article 8.2 is also the resource for arbitration, which might facilitate resolution to the problem that therefore should be supported. States not party to the Convention on Recognition and Enforcement of Arbitral Awards and the New York Convention and the Panama Conventions, a statement in the future of UNIDROIT Allowing parties to enter arbitration could be sufficient basis for the enforcement and recognition of arbitration awards. Of course, discussion in this regard with the representatives of countries such as those in Europe felt that arbitration should be understood essentially as a private law arbitration concept. Of course, Laliv disagreed in this context as well, noting that Article 8.2 of the Convention and the parties, if they were both states, could be agreed to arbitration and bring their claims before public international law jurisdictions. Chapter 2 of the Convention said that the claimants would be, as a rule, of private persons, and consequently, any public international law jurisdiction in that particular of the International Court of Justice in this regard should be excluded. In this, one must also note that while there is no concrete substantiating ground for cooperation, the inclusion of international legal mechanisms would make so possible. It is thought, therefore, a method of compromise between states and resorted to by only means of the parties. Neutral persons or persons such as arbitrators could be expected to determine the dispute by a judicial manner, therefore giving equal opportunity to the parties to put their case by weighing the evidence put forward by the parties in the cases and support their respective claims. Arbitration and the final award is conclusive and puts an end to the parties' disputes, thereby rendering the award binding on all parties. This would accept and voluntarily give effect to the arbitral decision, and the proceedings and the award are totally independent of the state. The extraordinary decisions, therefore, can be applied in the domestic courts to give efficacy to the arbitration agreement, or to regulate the arbitration proceedings, or to give effect to the award which has been non voluntarily signed by one of the parties. Therefore, what all in all this suggests is to bring the parties closer and closer together through judicial means. As the parties in an arbitral dispute present their case, the weakness in the case of one party or the other party may become apparent, thereby creating the opportunity to settle or resolve to means of negotiation, conciliation, or even mediation. This perhaps is one of the greatest strengths of arbitration. Therefore, three advantages come to light. First is the non national quality of the forum that could prove neutrality, the appointment of an arbitrator as an expert in the field. Third, and perhaps most importantly, the rules and regulations of the arbitration process could increase the speed and efficacy of the proceedings and reduce overall costs. There are perhaps two other benefits that could be included, which could retain the confidentiality of the arbitration and the problems of enforcement that are likely to be reduced if the consent between both parties is required to initiate the proceedings. In this regard, it must also be highlighted that the arbitral award does not represent a national forum. It appears at first sight to be more of a neutral position than a national court to pronounce itself if a state claims an award or a partial understanding of its national cultural policy in that regard, thereby limiting the award only to the award and to the object concerned. Therefore, three models of arbitration must be noted in this regard. First could be the International Center for Settlement of Investment Disputes as the natural institutional arbitration hub in this regard. Second could be the Santiago de Compostela resolution of the International Institute of International Law, IDI. Third, perhaps, could be the Permanent Court of Arbitration, and the two parties of which one is a party. Of course, this seems reflective of the discussions which can be brought about by the Secretary General of the PCA, which is available to facilitate the proceedings, and the International Bureau of the Permanent Court of Arbitration, which can offer administrative support and administers this through their means of procedure. A third significant advantage could be the rules for provisional measures or interim protections that can be offered in this regard. Therefore, the preservation of the objects pending to the resolution of the controversy offers a salient feature to this dispute. All in all, Article 8.3 of the UNITRA Convention states that parties may resort have to be resorted in provision measures, including proactive protective measures available under the law of the contracting state where the object is located, even when the claim for restitution or request for return of the cultural object is brought to the courts of competent authorities to another state. prohibiting thereby the exclusion of export to foreign states or to third party states. In this regard, Article 20 of the UNIDROIT Convention reads that the President of the UNIDROIT may, at regular intervals, request the five contracting states to convene a special meeting or committee in order to review the practical operations of the Convention. This could be used to facilitate the evolution of the Court of Arbitration for sports, for cultural property, as is for sports under the Court of Arbitration for Sports. Therefore, arbitration as a process must underlie the tests of identification and exploration of common interests of parties in this regard. Therefore, one of the advantages of arbitration would be that the contest of consent between both parties is understood and is noted in this regard. A famous example in this regard would be the Union of India versus the Norton Simon Foundation and the return of the stolen Siva Nataraja to India, which was postponed to enable the good offices acquired by the United States collector to display this for 10 years. In this case, the Brooklyn Museum, the lender of the statue, was appeased by the Republic of Turkey that was claiming to be donating $11 million for the artifact for the American Turkish Society. Subsequently, the American Turkish Society was sent a garland scorifice back to Turkey for the plaintiff country where the art remains on loan identifiably. Similarly, the Metropolitan Museum of Art in New York returned the Lydian hoard to Turkey after litigation had commenced in response to blackmail of potential successful lawsuits. Examples are a dime a dozen, but the construct of a party in the process that helps to create value for themselves in a wide range of disputes, small and large, must be noted. A neutral third party can design a problem solving approach which can create opportunities to promote interests rather than simply choose between positions, to design the participation of counsel of dispute resolution process tailored to the problem and the underlying interests, to help the party focus on forward-looking approaches, and to effectively and efficiently shape litigation in this regard. It is therefore a pity that the arbitration process was not available to achieve the same results for objects in hand. However, arbitration, even as a process, is something that is expensive, costly, and can run into millions. Therefore, one must make the case for third party funding as a plausible solution to this means to an end that is clearly motivated by those who are interested in achieving some sort of justice. Third party funding or agreements involve an independent financer, often specialized fund or investment firm, that provides capital necessary to pursue a legal claim. In return, the funder receives a pre agreed share of the financial recovery achieved at the conclusion of the dispute. This model has gained considerable traction in commercial and investment arbitration, where success fees and contingent agreements have been structured to align to the interests of the claimant and the funders. By applying similar principles to cultural heritage disputes, TPF can help overcome one of the most formidable barriers faced by African states. This also highlights the costs associated with enforcing rights under international conventions such as the UNESCO and UNDRA instruments. However, what must be noted in this regard is that the application of these cases needs to be of extreme importance. A growing body of scholarly work is also supporting this claim, which can argue that a third party funding can democratize access to justice, thereby enabling resource poor claimants to leverage high caliber legal representation. TPF not only reduces the immediate financial burden, but also introduces a competitive discipline that ensures claims are rigorously vetted before proceedings and reducing the likelihood of frivolous or unmeritorious claims in this regard. Of course, claims can also be made in regards of regulating consideration and mitigating risks of parties that are involved in third party funding disputes in the ICA for offering blueprints to such regulatory mechanisms. It is worth noting that while funders receive payments only upon a successful claim, naturally incentivizes claims of merit and of distinction. Implications in this regard for third-party funding would be limited by providing alternative source to the capital where African states, private owners can claim pursuits with greater confidence and determination. The shift would send a powerful signal to international communities, underscoring a renewed commitment to the safeguards of cultural patrimony against sources of illicit traffic. Moreover, TPF arrangements could become a commonplace, thereby fostering an environment of innovation and legal dispute resolution where funders are driven by commercial imperatives invested in the interest of successful processes and outcomes. This will lead likely to the development of efficient, streamlined arbitration processes, thereby including establishment of specialized cultural heritage arbitration centers where expertise in both international arbitration and cultural property converge and meet for tailored solutions. The financial relief provided by the TPF can facilitate to high access and high quality arbitration services, enabling resource constrained claimants to offer solutions in this regard. As African states and private claimants navigate the complexities of recovering stolen cultural property, embracing third party funding would not only limit financial capacities, but also a forward looking strategy that aligns with modern dispute resolution practices. By harnessing the market driven approach, cultural heritage, cultural identity, and the dignity of nations would be protected, thereby encapsulating justice in a form of financially driven motivation and involvement of parties. To end, or perhaps assimilate the discussions made herein, it is important to note that perhaps to begin with, membership to the UNIDROIT Convention and the UNESCO Convention are perhaps most important. A few African museums have a comprehensive interview of their collection. In the age of digital information, computerized registration of objects means that in cases of theft from museum objects, the relevant information can be passed to Interpol and identify international challenges immediately. The report by Amsterdam Conference of African Museums gives a rather bleak summary of African nations. Even the most basic facilities for adequate registration are lacking in the majority of African museums. Interpol, for instance, requested of the member states of the 1995 convention to supply offices of data commencement of stolen objects in 1994. Of the African countries, only Zimbabwe was able to supply adequate information of stolen objects. Areas of documentation and the handbook of standards published by ICOMOS in 1996 is the guide. However, only 6 African museums and the ICOMOS have been described as the most important document for international standards. Of course, Article 3.7 of the Convention states that public collection consists of groups of inventory and otherwise identified objects owned by the contracting state and regional local authority in this regard. The phrase otherwise identified cultural objects means other satisfactory means of evidence or identification which would be admissible in court proceedings to allow ownership other than conventional inventories. Therefore, in this regard, objects through diplomatic offices can be included. However, the means of private objects may make use of normal legal challenges available in the country where the object is located to seek a court order for the return of objects and make states of similar situations involved as well. What then perhaps is the point of the African Declaration in 1981, which noted that the African nations and the 1970 Convention relate to the cultural property is a matter of urgency. In this spirit of urgency, it must also be noted that the convention must find ratification with nation states. The convention may offer legal obstacles preventing stolen objects from entering the market, but the national laws to begin with must also be noted. However, harmonization, and perhaps to end with, harmonization is something that must be noted. Even in the richest countries with state of the art security, are seeing major thefts from public museums and private collections, as well as unauthorized digging and protection of archaeological sites, doing irreparable damage to cultural and archaeological heritage. African states, like many other states, must examine national legislations and protection of cultural heritage to make sure they are adequate to deal with current emerging challenges. Certain basic provisions are indispensable for successful protection of African cultural property, having regard for the various cultural properties and the cultural heritage of nations. The crucial point in this regard has been to join international conventions which have limited effect in overcoming the scourge of international trafficking. The next stage, perhaps, would be to harmonize the Organization of African Unity, as has been done by the United Nations and the European Union in some respects. The failure of African lawyers in this regard to recognize and show interest in understanding the value attached to their heritage is indispensable. The value of the Nigerian terracotta figures has raised up to $250 million. Burkina Faso, as an example, was setting a nightmarish scenario where Bobo priests were driven to suicide by the extreme anguish upon discovering the theft of villages' entire store of ritual objects. Many of those eloquent evidence of the magnitude of cultural properties has been a tragedy that has plagued not only a nation but an entire continent. Cultural objects and property and the access to the history of nations is at stake. It is the foundation for cultural and social identity. It enriches lives, protects joy, and sometimes the identification of daily life. The identity of peoples is inseparably bound with their cultural material and their cultural object. With those words, I once again thank the organizers for giving me an opportunity to share my thoughts and perspective. Thank you very much. And I do sincerely apologize for not being able to be present in Mozambique to deliver this speech and to share my thoughts and perspectives with everyone.